Yes, Mr Kolicaj.
Good afternoon, my lords. So I'll carry on. The procedural right that Mr Kolicaj wishes to be protected is the right to address the decision maker, Secretary of State, before a decision is taken. That right, we accept, could be remedied, would automatically be remedied by a full merits appeal in which a court stands in the shoes of the decision maker. And it could be remedied by a process which requires disclosure, gives Mr Kolicaj the opportunity to put in evidence in response to disclosure, and results in a subsequent review. Because in those circumstances, although for the reasons that my learned friend Mr Bundle took you to in the Balajigari case, although a post-decision, second decision is not as good as a first decision, it's a lot better than nothing. And in the particular context of a Section 42 appeal, it has to be the Secretary of State who conducts the review, because her decision will only be considered on public law grounds. There's no, as your lordships have held in all of the cases from Begum number 1 onwards, there is no power for the University Tribunal or SIAC to conduct or to exercise the Secretary of State's discretion for herself. So what we say has gone wrong here is that the Secretary of State took a decision without promising to the then appellant, without promising to Mr Kolicaj the opportunity to make representations after the decision and have them reviewed, and that error was continued throughout the proceedings in the first-tier tribunal, and the first-tier tribunal didn't correct them. That's the way we put the case, and that's in line with the way in which the case in which the Court of Appeal dismissed the Secretary of State's appeal and upheld Mr Kolicaj. The question of the difference between SIAC and the first-tier tribunal, some of those questions, my learned friend's absolutely right, they were not explored before the Court of Appeal. They simply didn't arise. It wasn't part of the Secretary of State's case before the Court of Appeal that the particular distinctive nature of an appeal, of a Section 42 appeal, remedied the failure to give prior notice. The Secretary of State simply considered that the failure was justified because of the need to stop Mr Kolicaj from renouncing his Albanian nationality. So can I take, rather than keeping on speaking in abstractions, I'd like to take your lordships, if I may, through the sequence of events. So starting with the policies which underlay the decision that was taken. So firstly, the published policy of the Secretary of State on deprivation, and you've been taken to it already, but if I could just turn it up again, it's at tab 43, page 477. Sorry, that's the statute. The policy is tab 40, page 453. And that, on any view, is an extremely broad indication of the way in which the Secretary of State will exercise her discretion. In fact, it's a definition of conduciveness. So it's it's tab 40, page 453, paragraph 55.44. Conduciveness means depriving in the public interest on grounds of involvement in terrorism, espionage, serious organised crime, war crimes, or unacceptable behaviours. And it's obvious that my respectful submission that doesn't give a person who wishes to make representations about about the Secretary of State's decision very much to go on. Unacceptable behaviours is such a broad mop-up that it's quite hard to argue that that I haven't been involved in an unacceptable behaviour. So that's the published policy. The next policy statement is the serious organised crime strategy, and it's a long document.
Is it you say it's a published policy, is it, I'm just wondering what it is. Is it guidance to Home Office, to border agency officials or Home Office officials?
So it's part of, yes, it's guidance to Home Office officials, and it's guidance to which you are referred, for instance, if you make an application for citizenship. So it's guidance which is on the Secretary of State's website, and I think it's common ground that that's published policy and intended to be. My learned friend's nodding, and I'm grateful for that.
And what's it called? Is it the immigration instructions? Or
no, it's the nationality. It's chapter 55 of the nationality guidance. Sorry, let me just the nationality instructions. I apologise. I think yes, it's the nationality instructions as they were enforced. They've been replaced by different versions now, but at that time there was still a very long document, which divided it up into chapters, and there are now freestanding bits of guidance.
Thank you.
The next maybe refinement of that published policy is the serious and organised crime strategy. That's at tab 39, starting at page 36. I don't intend to take you to it. It's a very long document. Because
at page what, sorry? Starting at what page?
Starting at page 376.
Thank you.
And the reason I'm not taking you to it is that the relevant bit of it is cited in the next document, and the next document...
I mean, we're using the word policy in a rather promiscuous way. This document at 375 is a command paper presumably laid before Parliament. Yes, presented to Parliament by the Home Office.
My Lord, I'm using the word policy in the way that it was used by the Secretary of State below, but it may be better that I just refer to these as documents. I realise that I'm rather foreshadowing a matter which is in dispute between us, which is our issue number 4. But so if I just refer to them as...
And I'm so sorry, what was the page reference you gave us for the serious and organised crimes strategy?
Well, I've not taken you to an individual page of it because I'm going to refer to it through the document which follows, which is the one at tab 37, the ministerial submission. It's a ministerial submission from the 13th. It's page 367. Sorry, page 362, tab 37.
It may help you if we're all working off electronic versions of the documents, so we need the page number to find it. Council still use paper, but we don't.
Well, it's difficult to I'm not yet worked out how to speak from a screen when I'm on my feet, I'm afraid. I find it just difficult to focus. So I do apologise. I keep forgetting. I thought I was being helpful by having tabs. So it's page 362, my lords, tab 37. And this is the Fiona Johnston letter. It's referred to in various places, and it's the document that we suggest by our 4th issue as a policy. So this is a ministerial recommendation. Recommends that the Home Secretary agrees that we should use the deprivation power against people guilty of serious organised crime, but limit its use to the most serious and high-profile cases. So that's the framing threshold which the policy sets out. It then goes into more detail. So and it's quite highly redacted. We don't have any concerns about the redactions. It looks quite likely that some of those redactions will be to do with the impact on foreign relations of depriving a person of their nationality, in particular maybe dumping a person on another nation. And it may be that that explains some of the reasons why the Secretary of State wishes or is advised to use this policy very sparingly. And it sets out the history. So starting on page 363, looking at paragraph 2, the power was tested on some members of the Rochdale child sexual exploitation gang, and as my learned friend has explained, following successful court judgments in those cases, the previous Home Secretary agreed to formalise the use of the conducive deprivation power for cases involving serious organised crime. And the aim, paragraph 4, is to deprive individuals of citizenship and to deport them from the UK. It's reference to the fact deportation may not always be possible, but it may yet be worth depriving some of their nationality. And then at paragraph 6, we consider there's a good case to pursue deprivation in serious organised crime cases as part of a wider government approach to tackling serious and organised crime, but only in the most serious and high-profile cases. And then that's the reference to the serious organised crime strategy, which I just referred you to a moment ago. The objective is relentless disruption and targeted action against the highest harm, serious and organised criminals and networks. Over the page, the substance of the policy, or what we say as a policy, the substance of the recommendation, top of page 364, is to mitigate the risks of expanding the use of deprivation to serious organised crime cases. This is at a time when, as the Secretary of State recognises, previously conducive deprivations had normally been used in terrorism or national security cases. So this is the point at which the decision is to expand the use to serious organised crime cases. We recommend focusing the policy on the highest harm offences. We expect the number of people, serious criminality cases meeting the threshold to be very low. Focus will be given to organised crime, particularly that involving violence, sexual and other high harm offences such as trafficking, organised drug importation and child sexual exploitation. We will make clear that decisions must be reasonable and proportionate, and then it goes on to consider various other considerations, the prevailing public interest, and so on. Now, that statement, and just jumping ahead, it will be common ground that recommendation was accepted by the Secretary of State, and it forms part of the basis upon which the discretion under Section 42 is exercised. And if someone was aware of that policy, and particularly that paragraph, they would be able to address the Secretary of State on some of the questions raised. So they'd be able to address the Secretary of State on the question whether they are one of the most serious and high-profile cases, paragraph 6, whether they have been involved in violent, sexual and other high-harm offences such as trafficking, organised drug importation and child sexual exploitation. Now, of course, I accept that that's not intended to be exclusive, but they are all harm offences. They're not dishonesty offences.
You can make these submissions to the first-tier tribunal.
Well, you can't, my lord, in my submission, because the first-tier tribunal can't take the decision for itself. It can only review the rationality of the Secretary of State.
Exactly so. It can say, this, after all, is not a high-profile case. The decision is irrational. And, I mean, are you... Well, I was going to almost... Sorry. Is it being submitted that a submission was made to the first-tier tribunal that this was not a most serious case?
Yes.
Right. And was that rejected?
The Secretary of the first-tier tribunal, I will come to this, concluded that the Secretary of State was rationally entitled to conclude, didn't decide whether it was or wasn't a high-harm case, concluded that the Secretary of State was entitled to treat it as being a high-harm case.
And are you contending before us that money laundering to the extent of £8 million for Albanian gangsters is not most serious?
Well, I'm not inviting your lordships to determine that point. I'm saying that there is a submission that plainly... So yes, I would make the submission that it's plainly not the highest harm offence. And I'll take you to the reasons why in a moment, my lord. But that's not the... I don't have to persuade... your lordships have no... I'm not making a submission to your lordships about perversity. What I'm saying is that the Secretary of State is the decision maker on this case, and the Secretary of State needed to have, or Mr Kolicaj needed to have the opportunity to make submissions about this policy on the basis of his offending to the Secretary of State, and for the Secretary of State to conduct a review of that policy. In normal circumstances...
One thing about this, we saw earlier that the Home Secretary did get a detailed submission about the respondent's individual case and took a decision.
Yes.
What does it matter if the decision was not in line with the ministerial submission of May 2020?
Well, because the Secretary of State said that it was. So the Secretary of State, in making her decision, stated that she had, the Secretary of State, in making her decision, says almost nothing, but the ministerial submission made to the Secretary of State, which we assume the Secretary of State was following, for these purposes we assume that she was following, stated that it was making a recommendation in line with the May 2020 policy.
Right.
I'll take your lordships to that document next. I was going to take you to it next, but one.
Right. So I think I see this. It's on page 345.
Yes.
Paragraph 5. So it's a setting, this is a discussion of the ministerial submission, and in paragraph 5, the Home Secretary is told, in response to the submission of the 13th of May, you agreed that use of deprivation power in cases with serious criminal convictions should focus on the highest harm offences.
Yes.
And then it goes on to say that the respondent has been assessed within these considerations, and we assess that he meets the threshold.
Yes, so we're not suggesting that the Secretary of State didn't have regard to the policy. We're saying that we didn't have the opportunity to make submissions to the Secretary of State before that decision. So at the time when this ministerial...
But you had this page 345 you had, didn't you? You had the ministerial...
Sorry, at the time of the appeal, but not prior to any review, we say.
So just to get it clear in my mind, you had the 13th May submission by the time of the appeal.
Yes.
And you have this document saying that the approach in the 13th May submission had been followed at the time of the appeal.
Yes.
So you could make any submissions you wanted
to the tribunal.
To the tribunal, which the Secretary of State, through being represented in the tribunal, would hear as well.
So, my lords, I'll have to address you on why we say that the Secretary of State being represented in the tribunal doesn't amount to sufficient review. But yes, I accept all of that. That's where this turns on. So I accept that we had these documents. I was just going to give you the order. So we've jumped ahead by one, but it may not matter. I did want to take you to the NCA recommendation, which is the next. So the first one was the May 2020 recommendation, which is a generic recommendation. The next one is the NCA. Well, just before I do that, the point, but this will save me coming back to it afterwards. My submission on the policy point will be based on the fact that on any view, if this is a policy document, then it is plainly a document which gives an appellant or a person potentially affected by it a lot more to say than the published policy in Chapter 55. So I took you to that. The published policy in Chapter 55 simply is a definition. This gives something to engage with and submissions to make.
Right. But you could do all of the difficulty I'm having is you can do all of that in the appeal. You've got the material. You can say, well, I'm not on a high-profile case.
Yes.
That's the policy being applied. Nothing secret. It's not a lumber-type case. It's not a secret policy. It's all out in the open, at least by the time of the appeal.
Yes, it was a secret policy at the time of the decision. It was a secret policy until a week before the appeal. But, my lord, yes, absolutely. At the time of the appeal, it had been disclosed. It's the first time it had been disclosed, we think.
Right.
But I will come to that, and I understand the point that my lord needs me to answer. But can I just take you through in order through the document? So the next document is the NCA, the National Crime Agency recommendation. And the NCA is not an agent of the Secretary of State. It's non-ministerial, non-departmental, sorry, a non-ministerial department. So on the face of it is not a, it's not able to act for the Secretary of State under the Carltona principle.
But why does that matter? I mean, they're just there making a recommendation.
Yes, it's simply because my friend suggested that there's no difference between national security witness statements and witness statements made on behalf of the NCA. It doesn't affect this case directly, but I just wanted to flag up or just put a marker down on that we don't think that's so obvious, because the nature of the NCA is quite different from the nature of a national security assessor within the Home Office. But so I'm at tab 36, page 359. And you've seen this already. The only reason that I wanted to take you back to it was to emphasize that the decision here, or the recommendation, sorry, here, is not based simply on the conviction. It's based on a risk of reoffending, and that's a risk of reoffending. So it's at the top of page, the bottom of page 360, the top of page 361. So just to clarify an issue that arose this morning, the trips to Albania after investigations started are accepted. Mr. Kolicaj has not sought to deny them. There was no factual dispute about them, and they were known to the sentencing judge. They do form part of the sentencing. They form part of the assessment of seriousness. So they're not a new point, which is raised for the first time in the NCA assessment. And the NCA, but what the NCA assessment does do, and does do for the first time, is conclude that it is likely that they, Mr. Kolicaj and his co-offenders, it's likely that they will continue to pose a risk following completion of their sentences.
Where do we see that?
Sorry.
Top of 361.
Top of page 361.
Thank you.
Sorry. So there's a reason given for that, and there's assessment of future risk. So on the face of it, that's a recommendation. There are other references. So at the bottom of 361, his continuing presence in the UK is clearly not conducive to the public good. Not quite as clear, but he will continue to pose a risk. That's on the face of it a reliance of future risk and not simply on past criminality when determining whether, or when recommending that the Secretary of State should make a deprivation decision. My Lords, then back to the document that my Lord Reid just took me to. So that's the document that starts at page 343, and it's tab 35. So this is the second ministerial recommendation. This is the one which is specific to Mr. Kolicaj, and it's the one which refers to the Fiona Johnson submission. My Lord, you took me there as well. Bottom of page 345, paragraph 5, and states that Mr. Kolicaj has been assessed within the considerations of the Johnson recommendation. And just to clarify, we're not suggesting it's not a part of Mr. Kolicaj. It's never been a part of Mr. Kolicaj's case, certainly since the upper tribunal, that the policy wasn't applied to him. And again, at paragraph 9, his criminality fits squarely within the parameters for use of the conducive deprivation power set out in Fiona Johnson's submission. It's considered that at the bottom, so on page 346, paragraph 9, towards the bottom of paragraph 9, it is considered that depriving Mr. Kolicaj of his British citizenship would be conducive to the public good because it would contribute to preventing and deterring further criminality. So it's the two aspects of conduciveness. It will prevent him from being a criminal, prevent further criminality, and deter further criminality. And in particular from the organised crime group, of which he held a senior and controlling role. And then on 10, not solely to sanction the criminality in this case, but also as a tool to protect the public. So that, again, there are two elements here. There's a punitive element, but also a punitive and deterrent element, but also a preventative element, based on the assessment that Mr Kolicaj poses a future risk. And then 11, the case for, so page 347, paragraph 11.
Here it's not confined to him, is it? Because it's, the end of paragraph 9 is preventing and deterring further criminality, in particular from the organised crime group, of which he held a senior and controlling role. It's not specifically Mr Kolicaj himself will necessarily be the person engaging in further criminality.
My Lord, I read it as being him and others.
Right. Yes, him and others.
And maybe that context is assisted as well by paragraph 11. So that's on page 347. This is on deportation. But remember, my lords, that the aim of deprivation is to enable deportation. The idea is a straight through. And deprivation will enable, made clear here, deprivation will enable deportation to be pursued, which would prevent him from engaging in further criminal activities in the UK. So, my lord, I absolutely accept, of course, that this isn't, that's not the only consequence. There's also deterrence as breaking up an organised crime group and so on. But part of this is the perception that he will reoffend if he's allowed to stay here. And the reason that's important is that on the face of it, that's the kind of reasoning which a person would wish to be able to answer, for example, by putting in a probation report which assesses him as being a low risk of reoffending. That's exactly.
How could he answer the risk of others offending? You accepted it was him and others.
Well, my lord, the answer would be that it might not be proportionate to the Secretary of State might review her decision if she thought this is a rational Secretary of State could, for instance, decide, well, I'm going to deprive this person of his citizenship because it will help to stop him from reoffending and it may deter others from reoffending. And then she gets evidence, she receives evidence which persuades her that he doesn't pose a risk of reoffending. She has to review. She might no longer think it's proportionate, she might think it's proportionate. But that's a matter for her to decide at first instance. And it's exactly the kind of submission that it's necessary to be able to put to a decision maker we'd respectfully submit. My lord, of course I accept that the Secretary of State could take the same decision rationally. It's not part of our submission that no Secretary of State could, certainly not part of our submission now, and for these purposes that no Secretary of State could conclude that this appellant on these facts, this respondent on these facts, fell within the policy. That's not what we're saying. What we're saying is that there would be good reason to go to the Secretary of State and say, this is no longer proportionate by reference to your own policy. It will also be possible to go to the Secretary of State, and I don't want to take you back into the sentencing remarks, my lords, because we've already been in there, but it's clear from the sentencing remarks that there are two, while Mr Kolicaj was plainly treated as having committed a serious offence, there were ways in which he was not at the highest level of seriousness. So, for instance, that although the amount of money which was estimated, the amount of money which it was estimated he'd been involved in laundering was high, it was not in the highest category. He was category 2, the level of harm. Similarly, his offence was not aggravated because of underlying particular forms of criminality. You'll see that in the sentencing remarks. There are two ways in which he doesn't fall into the highest harm category. Again, my lord, it may well be that the Secretary of State would say, well, tough, you're still bad enough, but it would be possible, it would be properly possible for someone to say, I got 6 years, I'm not at the highest level of harm, I don't have the aggravating features which would increase my sentence, I don't compare with someone who got 40 years for terrorism, I'm not high profile, I'm not highest harm. And that's a submission which we say has to be able to be made to the Secretary of State at first instance, because as we see from the first-tier tribunals grappling with that issue, all the first-tier tribunal can do is review the Secretary of State's decision on grounds of rationality. She doesn't stand in the shoes of the Secretary of State and decide whether she might change her mind. Or, sorry, the tribunal doesn't decide whether it might change its mind, and that's the difference.
But isn't it clear that the Secretary of State has not changed her mind, even when she knows the materials that you want to put before the FTT, or she maintains her case in the FTT?
So what I'll come to say is that what is needed in order for the Secretary of State's review to be updated in that way is for something from the Secretary of State or on behalf of the Secretary of State, not simply submissions by counsel.
That's what I'm struggling to follow, because submissions by counsel will reflect instructions given to counsel.
So there is never...
Counsel doesn't make up the policy. Counsel defends a decision that's been made.
So, no, counsel... Well, of course, that's right. But what counsel doesn't say in this case is there has been a review. Counsel is the review.
On the instructions of the client, the Secretary of State.
Yes, my Lord. So I've heard this. The submission I make is that there is a difference between a position put to a court by counsel at a hearing. There's a difference between that and what is envisaged. We respectfully submit in for instance, in U3, which is a review which is identifiable and which can be the target of the tribunal or of the court.
Isn't that just purely formulaic? What you're asking for is a note from some official saying, I've looked at all that, I haven't changed a single idea or a single approach.
Well, we don't have any note at all from the Secretary.
No, but isn't it just simply formulaic?
My Lord, so no, in my submission it's not formulaic. There is a difference between receiving something which shows a considered review and dealing with and counsel dealing with something on the hoof before a tribunal. And that's and the procedure which is identified in U3, we say is and in the case leading up to U3, and my Lords, I'm very aware that I'm speaking to the people who wrote U3. So if I'm wrong about that, the submission I make is that what follows from U3 and the purposes of the review process, which is identified in U3, is that there has to be something which is a target for the reviewing tribunal, not and the target must be a new case, a new review, and not simply submissions by counsel. Can I come back to that when I take you to U3? I see that this is an obstacle in my submissions, but can I take you through the next steps in the process? So the next step is that the decision itself is taken. I won't take you back there. It doesn't refer the decision. The decision which is served on Mr Kolicaj when he's in prison doesn't refer to any of these documents that I've taken you to. He doesn't. They're not referred to on the face of it. The decision refers to the previous conviction. It doesn't refer, for example, to any risk of reoffending. My Lords, it's at pages 340 to 341 of the bundle. You've been taken there, I think, twice by my learned friend as well. It's tab 34. Mr Kolicaj then appeals from that decision. He exercises his right of appeal. It's not certified, as Mr Blundell has explained, so his appeal lies to the First Tier Tribunal under Section 40A of the 1981 Act. And in response to his appeal, the Secretary of State serves a Respondent's bundle. And the Respondent's bundle includes the NCA recommendation, so the first of those recommendations. It doesn't include the ministerial submission. The consequence of that is that on receipt of the NCA recommendation, Mr Kolicaj appreciates that there is an assessment of him as posing a risk of reoffending, but he doesn't know anything about the May 2020 recommendation or its acceptance. and he's not able to address the Secretary of State by reference to that. He doesn't know that there is a high harm, high profile policy, and he doesn't know what's said in that policy about the types of offending which will be targeted. He doesn't know that the Secretary of State has committed to proportionate decisions. And there then follows quite a long process within the first-tier tribunal, where at the tail end of COVID and everything was delayed, that maybe that's why things were slow. But eventually, at the start of 2022, the first-tier tribunal gives directions. I don't think I need to take you to these. Gives directions for the Secretary of State to make disclosure, and specifically to make disclosure of the ministerial submission, and that finally results in that disclosure. And so you see...
I'm sorry, when you say results in that disclosure, does that mean both ministerial submissions?
My Lord, sorry.
December one? Or?
Yes, exactly. So it results, to start with, in the December one, and you'll see that... I should say first, actually, that on the 8th of February, Mr Kolicaj filed a provisional bundle. He had as yet not seen any of the ministerial submissions, and that includes the probation report.
And when was the FTT order that you just mentioned?
I'm sorry, can I just have a moment? So I'm not sure we have it in here. It's referred to in the disclosure letter from the Secretary of State, and that. So if my Lord, if you turn to tab 31, page 332. So you see that there's a direction that the respondent, there's an order made on the 10th of February 2022 that there would be a response to a disclosure request on the 6th of December 2021.
Okay, so the FTT order comes after the 8th of February when Mr Kolicaj put in the provisional bundle?
My Lord, yes, exactly.
Okay. And in response to that, you said he got the December submission. Did you get anything else at that stage?
The December submission and the annexes to it.
Okay.
So those are the annexes which, again, my learned friend took you to Annex C and Annex D in particular, which are and this, Annex B, which is the statelessness one, C is the human rights one, and D is the best interest one. And you see on page, while we're in this letter on page 333, the Secretary of State says, at this point, her position is there was no duty of disclosure, with reference to some of the cases which are in the supplementary bundle. The duty is not to mislead, and that the disclosure request is addressed in a spirit of cooperation. That's third paragraph of page 333. Now, we'd say that the ministerial submission was a document which the Secretary of State was required to disclose, even by reference to the rules which my learned friend took you to, and I won't take you back to in Nemo. And it was disclosed, but it was only disclosed late and reluctantly. It was then clear from that ministerial submission that there was another ministerial submission, the May 2021. That was then requested, and that then is disclosed slightly later on.
Can you tell us the date when that was disclosed?
So it was disclosed on the 23rd of March 2022, at the same time as the Secretary of State's skeleton argument. So Mr Kolicaj had already by this time filed his skeleton argument, and it was only after that that the ministerial submission, the May one, was disclosed. The next thing that happened was that the that Mr Kolicaj filed a short supplementary skeleton argument, and you'll see that at tab 26, page 296. And this is where, for the first time, Mr Kolicaj makes submissions about the policy, because it's the first time he's been able to.
And what's the date of this document?
That's the 30th of March 2022. You see that on the bottom of page 298.
Yes, thank you.
And you can see his submissions about the policy. There are submissions about the fact that it hadn't been disclosed and it should have been, and so on. But of relevance to us now is is paragraph 8 on page 298. And that is the appellant making his submission, or Mr Kolicaj making his submission that he doesn't fall within the policy. My Lords, can I step back to the previous document, which is the Secretary of State's skeleton argument before the first tier tribunal? So that's at tab 28, starting at page 301.
This is the Secretary of State's.
Yes, so it's the skeleton argument before the first tier tribunal. So it was sent at the same time as the May 2020.
So this is 23rd of March 22.
That's right.
Okay.
Yes, my Lord, yes, exactly. And just picking a couple of things out from that, page 301 over to page 302, paragraph 3, is the Secretary of State's reference in her skeleton argument to the NCA recommendation. And you'll see, my Lords, that the Secretary of State is still referring to the risk assessment, still relying on the assessment of future risk made by the NCA over a year previously, then makes a submission, or concludes at paragraph 4 that the appellant's suggestion that his offending is not of the most serious sort is plainly wrong. My Lords, of course, this is a skeleton argument which is served before the appellant had seen the ministerial submission, the May 2020 ministerial submission, so he'd not at this point had the opportunity to address the Secretary of State by reference to it.
But, I mean, it appears from this that even then you were making arguments that the offending was not of the most serious sort, because this is responding to something that Mr Kolicaj's lawyers had said, isn't it?
My Lord, yes, no doubt. So it would always be a submission in response to a deprivation decision that there were mitigating factors, or the offence wasn't as serious. But it's not by reference to, it wasn't made by reference to the policy. Yeah. Yes, my instructing solicitor confirms that. And then turning over to page 304, paragraph 9.5. So here this is the Secretary of State setting out the law and the understanding of the law following Begum number 1. And the Secretary of State's position is that the grounds for review, which my Lord Reid identified in Begum number 1, need to be assessed, so it's page 304, bottom of 9.5, fall to be determined as at the date of the Secretary of State's decision. So that's the Secretary of State saying, I don't look at stuff which postdates my decision.
I'm wondering where this is all going. It looks as if you're arguing that there was an error of approach by the FTT, and indeed by the Secretary of State, as a result of which the new material that had emerged in the form of the probation report was erroneously not taken into consideration.
That's right, Mark.
Now, your ground of appeal, if that's a good argument, it's one that could have been pursued before the courts below us, and if need be, could then have come to us. The ground of appeal you've got, at least the way it's put in the issue on page 18, was the deprivation order unfair for the reason that it was made by applying a policy which was not published and was not made available to the respondent until after the order was made. It's a different point.
My lord, yes. So this goes to our issue 1, which is the fact that there was no. The Secretary of State closed her mind to the possibility of there being a review, because she closed her mind to the possibility that further evidence should be admitted. So that's the maintaining of it. So the decision is initially made without prior representations, without any indication, without a system being in place for receiving further representations. And then when further representations arrive, or when further evidence arrives, the Secretary of State says, too late. I'm only reviewing this evidence on the basis of, I'm only reviewing what was before me at the time. And that's what we say was unfair. So the Secretary of State is, and the first tier tribunal doesn't correct that. So it was the first tier tribunal's job to correct that.
So it's got nothing to do with the application of a policy which wasn't published and not made available until after the order was made. I mean, that's all water under the bridge, because you have it by the time of the FTT hearing. The problem you're telling us now is that the FTT wasn't willing to consider evidence that came into existence after the order had been made, or indeed the decision had been made.
My lord, yes. So I'm within issue 1 now. I'll be very short on issue 4. But issue 4 is the non-publication of the policy, which was at the time of the at the time when the decision was made. But
well, you've got 3 issues in your cross appeal.
Yes.
Is it one of those?
No, my lord. We're in issue 1. We're in whether the so we're in the question whether the Secretary of State made and maintained a decision unfairly. And what we're saying is that the decision was initially a priori unfair because there were no prior representations. We accept that post-decision representations can remedy that, but we say that the Court of Appeal was correct, that in circumstances I'm
so sorry, I've just got a little bit lost. You say we're in issue 1. Which issue is that on pages 17 to 18?
It's paragraph 38A, as I understand it.
Well, that's what I wanted. Yeah.
Sorry, maybe I have it. So we're in the Secretary of State's ground of appeal.
Right.
First ground of appeal, which is...
So that's paragraph 38A, is that right?
This is that the Court of Appeal erred in saying that it was necessary for the Secretary of State to permit effectively a hearing or representations to be made by the respondent as part of her decision-making process before the appeal procedure.
My lord, no, during the course of.
Well, the ground of appeal is that at the time of when the Secretary of State made the decision, she should say at that time that she's willing to review her decision by conducting a merits-based evaluation in light of any representations or evidence which the person supplies.
Yes, my lord, there's no suggestion from in the Court of Appeal, and certainly not our argument that should have happened before the appeal was brought. It can be our submissions. It can happen in the context of the appeal in the same way as it does in SIAC. So it's clear what the Court of Appeal held was that the Secretary of State was entitled to make a decision without prior notice. Yeah. At which point, plainly, the way in which a person is likely to protect their position is to appeal and to make representations to the Secretary of State while the appeal is ongoing. There was nothing in the Court of Appeal. So what the Court of Appeal said was that there had to be in place, the Secretary of State had to make clear that there was in place a procedure which would enable representation to be made afterwards. It certainly didn't.
But it's a rather peculiar argument. I mean, in cases like U3, for example, and Begum 2 would suggest that there is no obligation of the kind that the Court of Appeal thought there was, but that the appeal procedure enables representations to be made and evidence to be placed before the tribunal.
Yeah.
Now, your argument seems to be that because the tribunal didn't follow that procedure in this case, therefore, the Secretary of State was under a duty to entertain, to invite representations and evidence in the way that the Court of Appeal had supposed.
So, Molly, so what we say is that if this appeal was in SIAC, the Secretary of State wouldn't need to say it, because everyone would know that once someone brought an appeal to SIAC, there would be an exculpatory review, there would be an opportunity to put in further evidence, there'd be a second review, there would be the rolling or the reactive review process, which this court identified in U3. The Secretary of State would know that. It's because that wasn't the process in the first-tier tribunal that it was necessary for the Secretary of State to take responsibility for it. We say that all that SIAC is doing is regulating the Secretary of State. So what SIAC is doing is ensuring that the Secretary of State has the opportunity that an appellant has the opportunity to make representations to the Secretary of State, and that the Secretary of State has the opportunity to review them. And because that process exists in SIAC, then, as my learned friend recognised today, and as follows from the judgments in Begum number 2 and in U3, if the Secretary of State receives evidence which is material and important, and chooses not to issue a further decision or not to change her position, then she may be vulnerable for that reason. So what we're saying is that the SIAC appeal procedure, one of the things that it does is it regulates the process whereby the Secretary of State receives new submissions, reacts to them, generates a new decision or a new implied decision, but at the moment, well, it doesn't matter which, but generates a new target for the appeal.
That's a different argument. You're saying that the procedural fairness in SIAC is different from the procedural fairness in front of the FTT. And the issue now being considered is just because the tribunal didn't follow the procedure set out in U3, N3 and Begum, that you are entitled in some way under the Secretary of State's appeal to raise this issue, that the probation report wasn't considered, wasn't admitted in evidence. I mean, it's no part of your appeal, but you're trying to get it in under the Secretary of State's appeal.
But it's at the core of the Secretary. So the Court of Appeal concluded, and I can take you through the Court of Appeal's judgment. What the Court of Appeal looked at materiality, and it looked at what. What the Court of Appeal did was it recognised that there were good reasons for not giving prior notice. It then looked at whether the system itself was then fair, and it considered that because of what it understood to be the jurisdiction of the tribunal on appeal, the Secretary of State would have to fill the gap. And what the Court of Appeal did is it gave examples of submissions which the appellant before the first-tier tribunal might have wished to make, and it gave the two examples that I've referred to again today. But I'm not trying to smuggle in a new ground of appeal. It's the Secretary of State. It's the Secretary of State's ground of appeal is that the distinctive appeal to SIAC, the distinctive appeal under Section 42, is sufficient remedy for any initial unfairness. That looking at the system as a whole, it's fair. And therefore we say these are the things that it didn't do. These are the ways in which the first-tier tribunal did not provide those remedies. And we go on to say that that's a result of a kind of parting of the ways between SIAC and the first-tier tribunal, which results in different procedures. So there are greater protections in SIAC than there were in the FTT at this time.
But I mean, if the FTT ought, applying the law properly itself, to have admitted, let's say, the probation report, then if we're asking ourselves, is the system as a whole fair, it will be fair weighted because it'll achieve exactly what is achieved by SIAC. All relevant material can be put before the FTT as it can be put before SIAC. The Secretary of State, in conducting the proceedings in the FTT, has to decide what position to maintain throughout, as she does in SIAC. And either she'll concede, because the new material causes her to change her mind, or she'll maintain her position, both in the FTT and in SIAC. If she maintains her position, there is, well, as you put it, an implied continuing decision to hold in place the deprivation decision.
My Lord, I've said implied just to avoid going back over the...
I know, sure, but
yes.
I was trying to capture the way that you
no, absolutely, my Lord.
because you accept that that's all true of SIAC. What I'm struggling with is why it's not all true of the FTT.
So what we're saying is that the decision of the Court of Appeal which we are seeking to uphold is a decision that the Secretary of State acted unfairly and that the FTT should have so. And what the Secretary of State did, which was wrong, was to decline to consider new submissions. So she didn't give a prior opportunity to, for reasons which we understand, she didn't give an opportunity for prior representation. She then did not give the opportunity to make further representations to enable her to change her mind. And those are...
I think we understand your argument.
Yes.
The Secretary of State erred and the FTT was under the same error in both treating the issue as being the, if you like, the rationality of the original decision.
By reference to the original material.
And therefore, subsequent evidence was immaterial. So I understand that point. The difficulty I have is seeing it as an answer to the first ground of appeal for the Secretary of State, which is about how should the procedure work.
But that's what the Court of Appeal held was that the post-Begum number 1 function of the First Tier Tribunal was such that it was a strict judicial review. It didn't admit fresh evidence. And so and it was against that backdrop that it concluded that this decision was unfair. Yes. And we're saying that as a matter of fact, that is what happened. And that's why, so the Secretary of State didn't admit new evidence and consider it, and the First Tier Tribunal didn't correct that. My Lord, so it's not a rationality, it's not an... It's still a fairness challenge. It's that the Secretary of State didn't operate. It may be that it could be characterised in other ways as well, but the way in which the Court of Appeal characterised it and what we seek to uphold is a finding that the totality of that decision-making and decision-maintaining process was unfair because the compensatory opportunity to make submissions wasn't there. Lord, I'm not sure... That's, yes, I think you have my submissions.
I think I've got the point.
Yes, but can I just ask you, can you show us in the FTT judgment where they, well, whatever they do in relation to the probation material?
My Lord, yes, so I will...
Well, paragraph 61
is
perhaps the nearest to page 160 in our bundle.
Well, just... Yes,
we see, they say we reject the criticism that the respondent, that's the Secretary of State, ought to have taken into account in making her decision the assessment of risk, which is contained in a document that had not yet come into existence.
So she couldn't be expected to go looking for the document, and she couldn't be blamed for not having had regard to a document that wasn't before at the time of the decision. That's following the line which she was encouraged to take by the Secretary of State, we say.
Right.
Yeah, so you say everybody got it wrong. The Court of Appeal, proceeding on the same erroneous basis, found a solution, which is what's now being challenged in the first ground of appeal.
Exactly, my Lord. Yes. So the Court of Appeal viewed it through the prism of a duty examination of fairness, looking at fairness in all of its circumstances, including the availability of a post-decision appeal, and it concluded that the entirety of that process was unfair, and that the Secretary of State had failed to had maintained its decision without in a way which was unfair. about. That's what we understand to have been. That's the reasoning of the Court of Appeal which we invite your lordships to uphold. Lords, I was going to take you to many other documents, but I think I must move on to other grounds. You'll have from our written case the various places where. Let me just give you the paragraph references, but there's a discussion in our written case of firstly of the various procedure rules and practice statements in SIAC and in the first tier tribunal. You'll have those, so it's page 60 of the core bundle, paragraph 21 onwards, and then from paragraph 29, page 63, through to paragraph 41, page 71, you have our submissions about all of the cases, most of which you've been taken to by my learned friend this morning, and in particular the sections of the U3 judgment which we say require that, require that there be a sufficiently identifiable decision in response to further evidence in order to become the new target of the appeal. And we say that when the Court of Appeal in Begum number 2 was referring to a distinctive appeal, and when Lady Justice Lang in U3, before it came to my lords, looked at the need to examine decisions as meticulously as possible, the appeal that they were looking at was the particular appeal to SIAC, and that the reasons why a structure like the SIAC structure was needed was not simply because SIAC involves closed proceedings. My learned friend suggested this morning that the need for additional protections in SIAC is only because of closed material, and we say that's not right, that there are two inherent unfairnesses to deprivation decisions. This is page 67, paragraph 36 of our written case, Lady Justice Lang. There are the two different inherent unfairnesses. Firstly, the fact that the appellant has no input into the decision, and secondly, that the decision is based in part on material which she never sees. And the whole of the SIAC proceedings, the whole of the SIAC procedure is to deal with both of those, and not simply with the closed nature of SIAC proceeding. And so that's our answer to my learned friend's submission that the distinctive nature of the Section 42 appeal is sufficient to guarantee fairness. We say it's not the Section 42, or sorry, the appeal from Section 42 decision, it's specifically the appeal to SIAC which guarantees fairness. My lords, I'll move on to the other issues, if I may. So I think we've agreed that I've got till 3:30 just to make up for this morning. So the second issue is the one I'll also deal with this very shortly. It's the issue about the power to make or not make an order. Our short answer to that point is that if I have three things to say. The first thing to say is that this really makes no difference to the relations between the parties now. Everyone agrees that if the Court of Appeal had been right, if the Court of Appeal was right, if you conclude the Court of Appeal was right to allow the Mr Kolicaj's appeal, then the order will cease to have effect from now on, and Mr Kolicaj will be British. And we also recognise that for all the reasons set out by my lords, Lord Sales and Lord Stevens in N3, that nonetheless the fact that the order's been made has past consequences. In particular, it protects, it authorises, it continues to authorise enforcement action taken by the Secretary of State. following the making of the order. So, by way of example, Mr Kolicaj was briefly detained in immigration detention following the making of the order. The consequence of N3 is that it's not open to him to say that he was British at that time. So, of course, we understand that. But now, we slightly struggle to understand what the difference now is for the Secretary of State, or what difference it makes to the Secretary of State to identify an error in that made by the Court of Appeal. We also gently, we're not trying to in any way take a pleadings point about the fact that the order was filed by the Secretary of State and so on. We simply say that if there is a question about the Court of Appeal's jurisdiction and whether the Court of Appeal has the power to quash an order, that this court should deal with it in a case where it's actually been asked to. What happened was that the Secretary of State filed an order, filed grounds of appeal which challenged the making of the order. In those grounds of appeal said that she would seek to negotiate with Mr Kolicaj's representatives a variation of the order, which would have been negotiable. The Court of Appeal then wrote to the Secretary of State and said, you can make a submission to us, explain to us why you think we don't have jurisdiction, and the Secretary of State didn't go back to the Court of Appeal. And we simply say that, and we've identified in our written case, that on the face of it, it's not obvious that the Secretary of State, that the Court of Appeal had no power to vary that order and should have been asked to do that rather than the matter coming to your Lordship. But our third point is this, that we don't understand on what basis the Secretary of State says that the upper tribunal would have no power to quash an order, and we don't understand on what basis the Secretary of State says that the Court of Appeal has no power to do so. On the face of it, the Secretary of State is hearing an appeal which concerns an order and can make, which concerns a deprivation order and can make a decision disposing of that order. The decision can be made in such a way that it makes clear that it's not treating the deprivation order as if it's always been a nullity in the extreme version of nullification that my Lord's dealt with in N3. We're not suggesting that, but surely it was possible. We don't understand on what basis it said that the Court of Appeal had no power to make an order quashing a decision where that decision was part of the proceedings before it, a decision that was consequent, that was the implementation of the decision from which it was hearing an appeal. And just in the same way as my Lord's indicated to the Secretary of State in N3 that as a matter of that it would be appropriate for an order to be formally withdrawn by the Secretary of State, then if there is a warrant, if it's appropriate for the Secretary of State to do that, then no doubt a court could also order that a deprivation order be quashed. So, Mills, those are our answers on that point. We don't, it's not a matter which greatly impacts on Mr Kolicaj. So, can I move on to the other three issues? The third issue is the specific question. So, Mills, as I said, for the purposes of issue 1, we assumed that the Court of Appeal was right to conclude that there was a good reason for giving no notice of a deprivation decision, and we assumed that the Court of Appeal was right to conclude that if you give notice of the deprivation order, the consequence of that is the frustration of the purposes of deprivation. And we understand, of course, the reasons why that would be the case. The statutory purpose, again, N3 is helpful on that. We'd respectfully submit it's clear that the statutory purpose includes not giving a person the opportunity to frustrate a deprivation order that you're trying to make against them. And so there would be, on bank mallet grounds, there would be good statutory context reasons for departing from the normal presumption that the presumption that prior representations can be made. All of that is fine. The alternative way of looking at it through the bank mallet lens is that it would be impractical to give an opportunity to make prior representations, because a person will use that opportunity to frustrate the making of the order. So that's the basis upon which the Court of Appeal concluded that something different was needed to protect fairness, a post-decision opportunity. And by our issue 3, we question whether the Secretary of State has demonstrated that there is a real possibility of renunciation and a real possibility of the frustration of the deprivation procedure in this particular case. And what we say is that the burden lies on the Secretary of State, who is responsible for taking a decision or adopting a procedure which is prima facie unfair. The burden is on the Secretary of State to demonstrate why that departure from procedural fairness is necessary. And, my Lords, you have our submissions on this.
Sorry, can I just check? Can this submission stand if it's the first limb of the bank mellet exclusion of procedural fairness which applies? In other words, necessary or express words or necessary implication from the statutory scheme excludes the requirement of additional procedural fairness at the first stage. I follow the submission if you say that the focus is the second impracticality point. Then I think I understand that you're saying Secretary of State didn't demonstrate impracticality. But if it's the first limb, that the statutory scheme simply excludes the need for other procedural fairness at that first stage, does your argument run for that?
My Lord, no, that must be right, that it doesn't run. So if the statutory scheme excludes the need for prior representation, but necessarily excludes, then it doesn't run. If the statutory scheme, and in particular the processes which are adopted by, so SIAC, just to use SIAC again as the example, SIAC adopts procedures while regulating its own, in the course of regulating its own procedures, it operates protective mechanisms which ensure that it can properly determine the appeals before it. And if it only adopts those in order to protect against a prior unfairness, then what SIAC is doing is my Lord, no, sorry, that argument doesn't work, does it? I'm not sure that I'm not sure that that's going anywhere. So
okay, you gave a clear answer to my question.
Yes, I think I'll stick with my first answer. May I?
Forgive me, I'm not sure I understood the answer. Are you saying then that this argument runs within the second limb of Bank Mellat? But not with accepting that it doesn't run within the first.
I've not thought of a way of explaining why it would run under the first limb. I have to say I hadn't foreseen this question, and I should have done. And I'm just trying to.
But you do. On my understanding of the case against you, it says that this is a first limb Bank Mellat case, and that's why I understood we were taken to Begum 2 to demonstrate that it was a first limb Bank Mellat situation. In other words, exclusion of requirement of additional procedural fairness at the stage we're talking about by virtue of the statutory scheme itself as a matter of necessary implication.
Yes, Maud, so you have our submissions on the statutory scheme point, which is the statutory scheme which is contemplated there is SIAC.
Right.
So that's but if there were a SIAC, I think it would have to follow from. Well, I may need to take instruction on this. It's my oversight if I haven't thought of the consequences of the Secretary of State's position on this. So I'd certainly formulated this as a Bank Mellat 2
Yes.
circumstance. You have our submissions on why Bank Mellet 1, first limb of Bank Mellet, doesn't apply in a case which is out with SIAC.
Yes, thank you.
And the can I just have a moment and 30 seconds to think about that question? My Lord, no, I think it must be right. So if you're not with me on Bank Mellet 1, then this doesn't get us home.
Yes, right.
But if it's a question about impracticality, then you have our submissions on this. And our submission is that on the face of it, it's not there is no sufficient basis for presuming that a person in Mr Kolicaj's position can renounce his Albanian citizenship with such speed that he can frustrate the deprivation procedure. And the reasons we say that is that again, on the face of it, renunciation proceedings or renunciation processes are not immediate. And we've set out the reasons for those by reference to renunciation procedures in the UK. There have to be checks of identity, there have to be checks of age, there have to be checks of capacity, there's a fee to be paid, then there's a check in particular of that you're not rendering yourself stateless. And Albania, which is a signatory to the Statelessness Convention, could be expected, or at least one could imagine that there would be a similar process in Albania. And so we say that the Secretary of State, it's not a very onerous requirement on the Secretary of State, but in order to depart from the normal requirements of procedural fairness, then the Secretary of State simply needs to make an inquiry as to what the process is for renunciation in a country in which a person is a dual national. Because if the second nationality, if it were Albania wishing to exercise an Albanian equivalent of Section 42, then the appellant simply couldn't instantaneously renounce his British citizenship. He would have to go through a process which would take some time. I don't want, if I may, avoid taking you through the statutory provisions and the policies which I've referred to in the written case. They're there. So then the fourth issue is the issue of the policy. And again, you have our submissions about that in the written case. I'll just expand on them slightly. I've taken you through the history of, or the archaeology, I suppose, of the Secretary of State's policies on the exercise of the Section 42 discretion. And what we say is that you already have my submission on this, that the ministerial submission of May 2020 was adopted by the Secretary of State, and it governs, she at the relevant period, it's gone, it was replaced by a published policy in 2023, but during the relevant period, it governed the exercise of her discretion because she'd accepted it. And we say that it's the kind of policy or it's the kind of, I realise I'm assuming what I'm proving, but it's the kind of policy which the Supreme Court thought should be published in Lumba, because, and so this is Lumba tab 85, page 1721, paragraph 38. It's a very well-known passage. What must be published is that which a person who is affected by the operation of the policy needs to know in order to make informed and meaningful representations to the decision maker before a decision is made. And we say that impliedly that includes before a review is conducted. Do I need, if I'm Mr Kolicaj, to know what's in the ministerial recommendation in order to make informed representations? And I say in my submission is that I do. If I haven't seen the ministerial submission, all I have is that one sentence description, definition of conduciveness in chapter 55 of the nationality instructions. If I have the ministerial submission, then I know what kind of conduct the Secretary of State is considering penalising by way of a deprivation and why, and I can make submissions about that.
But we've seen that you did. That was the supplementary skeleton that you put in Mr Kolicaj in the FDT that you showed us. I mean, those were precisely submissions directed to the 13th May formulation of the policy.
So, my Lord, yes. But the policy was unpublished at the time when the Secretary of State made her decision. It continued to be unpublished at the time when, for example, the skeleton argument was published, when the initial skeleton argument was filed at the time when the initial evidence, in fact, at the time when all of the evidence was filed. And for the period of time when it was unpublished, then the Secretary of State was relying on it unlawfully. It's a document that should have been published. As our submission, I accept, of course, that it was ultimately published and submissions were made in reference to it. The Secretary of State then did not conduct a new review of these So you, my Lords, will have seen, because I took you to that supplementary submission, that specific points were raised about the kind of offending and the nature of the sentence. The Secretary of State didn't review her policy or didn't review her decision in light of those submissions.
Simply because I've referred to that skeleton argument, can I mention that we've got that skeleton argument twice in the bundle? Do we have anywhere the original skeleton?
My Lords, yes, you do. So that's one of the documents that was corrected in the supplementary bundle. So, it was included. I'm sorry about that. Well, it was just.
No, that's fine.
We all agreed that there came a point when the bundle had been amended so many times.
Yeah, no,
it would probably be quicker to get it to you.
Okay, yeah, I follow. Thank you.
So that's where it is. Yeah. Yes, it's tab 2, my Lord. Thank you. Yeah, so the original skeleton argument before the First Year Tribunal was in the supplementary bundle. So I didn't take you there. I thought I was taking you to enough long documents already. So, just on the question of policy, my Lord, So our submission is that for the period of time when decisions were being taken by reference to policy, which wasn't published, the Secretary of State was acting unfairly, and that by the time that the policy was published, it was too late to make effective submissions about it, and primarily the Secretary of State then did not review her decision in light of that policy. Sorry, I'm just. The Secretary of State relies on the fact that that SIAC on 2 occasions has concluded that the policy, or that the document, the ministerial submission, is not a policy. I'd invite you to note that it was common ground before the First Year Tribunal that it was a policy. The Secretary of State, in her skeleton argument, referred to her policy as being made up of the 3 documents I took you to, so the nationality instructions, the serious organised crime statement, and then the ministerial submission. And the First Year Tribunal took the same approach again and recorded that it was common ground before it that the ministerial submission was policy. We say that that position which was taken by the Secretary of State before the First Year Tribunal was correct, and that with respect that the conclusions of SIAC to the contrary, and there's an really over to reference to this as well by Justice Lang in D5, D6 and D7 that with respect that they were not right, and that that a document like this, which is a recommendation accepted by the Secretary of State and expressly relied upon by the Secretary of State in making a decision, and which sets out factors which are relevant to the exercise of the discretion and upon which a person might want to make submissions, is precisely a policy of the kind identified in Lumber. We, as we've said in the in our written case, paragraph 82, page 88, we're not submitting that the policy gave rise to a legitimate expectation, a substantive legitimate expectation. Of course, we're not saying that the only possible outcome or the only rational outcome for Mr Kolicaj under the policy was that he wouldn't receive a deprivation decision. That's not what we're saying. We're relying on the fourth of the Lumber reasons why policies should be published, the one that's at paragraph 38 of Lumber. And then the final issue which we raise is that, and I'll deal with that very shortly. Indeed, you have our submissions on it. It's issue 5, and we say that for the reasons that it gave, the upper tribunal had been right to conclude that the Secretary of State had not distinguished between the condition precedent satisfaction that Mr Kolicaj's the deprivation of his citizenship was conducive to the public good. So the Secretary of State didn't distinguish between that condition precedent and the exercise of her discretion afterwards. And we say that, so firstly, that it's common ground that the two are separable, and it's clear from a reading of the statutory provision in any event of section 40 brackets 2, but we've referred to the Begum, my Lord's judgment in Begum number 1, paragraph 67, which is tab 72, page 1292, which distinguishes between the statutory condition which must be satisfied and then the subsequent exercise of the discretion.
I'm so sorry, could you give that page reference?
Sorry, yes, it's 1292, my Lord.
Thank you.
And in her written case, the Secretary of State accepts, and this is tab 2, page 51, paragraph 69, that deprivation did not follow automatically once the threshold of involvement with serious organised crime was met. So as a statement of the statutory position, that has to be correct. And what the Secretary of State's case is firstly that the Parsons submission, so the ministerial submission from December 2020, fills the gaps, because that makes absolutely clear that the Secretary of State was aware that she was being invited to exercise a discretion. She was aware that she was doing so. We don't submit that the Secretary of State was wholly unaware that she had a discretion. We submit that she either failed to exercise it or she failed to show in her decision that she'd done so. We say that the decision itself should not be read as incorporating the ministerial submissions. The ministerial submissions were not disclosed until over a year after the decision itself, and the Secretary of State made clear that she didn't believe that she was obliged to disclose them, and we say that's a strong indication that at that time she didn't treat them as being part of the decision, not being intended to be part of the decision. And we say that the wording of the notice itself, and so that's on pages 340 to 341, tab 33, appears to proceed directly from the Secretary of State's assessment of the seriousness of the offending and from the Secretary of State being satisfied that deprivation would be conducive to the public good, to the deprivation itself. So there's no gap for discretion between those two points. And we say that the upper tribunal, so the Secretary of State, relies on two things. She relies on the recommendations and asks that they be read alongside the decision. She also relies on the reference to Section 55, and she says, why would the Secretary of State be referring to Section 55 if she didn't know that she was exercising a discretion? We say the upper tribunal was right for the reasons it gave. Tab 6, page 144, paragraph 65, that the reference to the best interests of the children didn't demonstrate that discretion had been exercised. And our primary submission about that, in addition to the reasons given by the upper tribunal, is that on the Secretary of State's own understanding of Section 55, we say that Section 55 was relevant to her decision to the limited extent that it engaged Article 8 VCHR. And we know that from the Secretary of State's stated position before the upper tribunal, and that's page 139, sorry, tab 6, page 139, paragraph 50, the Secretary of State said that prior offending had been the sole basis for her decision. And in those circumstances, we say that the upper tribunal was both entitled and right to reach the conclusion it did at paragraphs 62 and 63, that's tab 6, page 141, to reach the conclusion that the Secretary of State had progressed...
Page again.
Sorry, it's page 141, my lord. Tab 6, paragraph 62 to 63. It was right to progress... So the upper tribunal was right to say that, to hold that the Secretary of State had progressed directly from her assessment of the seriousness of offending to a conclusion that the respondent should be deprived of citizenship. And our final point is that the Court of Appeal agreed with so the Court of Appeal overturned that, and we respectfully submit it was wrong to do so, but it agreed with the upper tribunal, and that's paragraph, so it's tab 5, page 116, paragraph 36. The Court of Appeal agreed with the upper tribunal that the decision on discretion was inadequately reasoned, and for that reason also, the Court of Appeal, we respectfully submit, was wrong not to uphold the upper tribunal's decision. Alternatively, that provides a further reason for upholding the Court of Appeal's decision. My Lords, I'm grateful. I've slightly overrun, and no doubt my learned friend can take the extra minutes as well back. I'm grateful. Unless I can help you any further, those are my submissions.
Thank you very much, Mr Kolicaj. Yes, Mr Blundell.
My Lord, I'm grateful. I'll be as brief as I can. Can I make just 3 points in reply on the Secretary of State's case before dealing very briefly with the Respondent's notice points? Point 1 in reply is in relation to the Chowdhury decision that you were shown. To recall, you were shown that this morning. It's behind tab 74, beginning at page 1326. The relevant passage you were shown was at page 1334, and that's paragraph 29, dealing with the history of the statutory provisions. It's a statutory history background. I go to that just to make 2 points. One, this was obviously a case that myself and Ms Wakeman were in. This passage, though, was not based on any submissions which we had made. You will see that from the beginning of the passage. As my learned friend indicated, the same constitution of the Court of Appeal sat the following week to hear the Daci case. And Ms Smythe, who was also part of the council team in Chowdhury, also appeared in Daci. and my understanding is that a note was provided by her dealing with the statutory history. So that's where that comes from. In my submission, it doesn't assist my learned friend because it goes no further, and this is the court's reading of that. As I understand it, this wasn't the Secretary of State's submission in DACHI, but certainly, in any event, it goes no further than saying the effect of Rule 8 in the deprivation rules that I handed up this morning is that for the purposes of that statutory inquiry, the Committee of Inquiry had what was termed there a de novo fact-finding function. Now, whether or not that's an entirely correct way to describe it, one still butts up against the point made by my Lord Briggs in argument with me this morning that, in fact, there's no indication at all in the rules as to what you're supposed to do as the Secretary of State with whatever conclusions are drawn by the Committee of Inquiry. So it may well be that the Committee of Inquiry, having received new evidence and heard submissions, could reach particular conclusions, but that doesn't make it an appeal, and nothing in the rules made it an appeal. It was a highly limited form of statutory Committee of Inquiry procedure, which didn't oblige the Secretary of State to do anything in response. That's the point about Chowdhury. And I'm told that there was no note, no accompanying note provided in DACHI. It was simply a bundle of statutory materials, which the court was then taken to at the oral hearing. The second short point in reply is about the Albanian trips that you've heard about. So one of the points made to me in argument this morning by my Lord Stevens was whether or not the tribunal could have heard evidence from Mr Kolicaj about the Albanian trips after the investigation had been launched. And I said, yes, they could have done. The point made in response by my learned friend, as I understand it, is that, in fact, the Albanian trips were taken into account in the sentencing remarks. That is true, but only insofar as it goes. You will see, if I can ask the court to turn to the sentencing remarks, at page 369 of the bundle, right at the bottom of the page, you'll see that Her Honour Judge Kent said, I'm satisfied that the Kolicajs had a leading role because they were not supervised when they travelled, and Gjelosh Kolicaj had the keys to the suitcase containing the large amount of cash that was checked in. And the evidence is that on 2 occasions after cash was seized by the authorities, Gjelosh Kolicaj went directly to Albania. The inference is that he was liaising to those who were the intended recipients of the money in Albania. So that is all correct. It took into account that much. But in the NCA submission, the NCA went very slightly further, and at page 360, again at the bottom of the page, the passage I took my lords to early this morning, the NCA there says it was the NCA's assessment the purpose of this trip was to meet with the intended recipients of the cash to plan a response to the disruption of the OCG. So the extra bit of assessment from the NCA was about the planning of disruption. Now, one might say that can be fairly inferred from the fact that the sentencing judge took into account that Mr Kolicaj was meeting the other members of the gang. And in a sense, this is a point against myself, because if it was a point that was taken into account in sentencing, well, there was no more that needed to be said about it in the first-tier tribunal. But if I'm wrong about that, and this was an additional point taken by the NCA, my response this morning still stands, that was something absolutely Mr Kolicaj could have dealt with if he wanted to. And then the third short point of reply is simply in relation to ground 2. You've got my submissions on that already. Ultimately, the fundamental point about the powers of the tribunals below is that the FTT is a creature of statute. It was created by Section 3 of the Tribunals Courts Enforcement Act 2007. It therefore only has those powers which Parliament has given to it, either under that enactment or any other enactment. There is no statutory provision giving the FTT a power to quash a deprivation order, or indeed anything. So where Parliament has wished any part of the tribunal structure, either upper or first-tier tribunal, to quash, it's said so expressly. And one example of that, not in the papers, but we will provide copies of the statutory provision in due course, is in Section 15 of the 2007 Act. There is a provision for the upper tribunal to be able to quash in judicial review proceedings brought before the upper tribunal. So the court, I'm sure, is aware that the upper tribunal has a judicial review jurisdiction. For those purposes, it's given effectively the classic prerogative writs, but it has to be given those powers by primary legislation. It wasn't done for the first tier, therefore the first tier didn't have the power. The upper tribunal on appeal only had the powers of the first tier, and the Court of Appeal by CPR 52.20 only had the powers of the court below. So for all those reasons, there simply wasn't any power to quash.
Do we have section 3 available?
We don't. Can we provide that at the same time? I noticed that was missing over the time adjournment. I'm sorry. And I should say, it may make sense as we've gone to some of the, or we've at least referred to the bundle of materials in DACHI, we can provide that very easily to the court as well, so you have the full history going back to 1914 in the century. Then on the respondent's notice point, so respondent's notice point 1 is effectively the fact-specific challenge to the exclusion of the right of prior representation. Well, the short answer to that is that if Begum 2 is right, and it is right because this court refused permission to appeal on this point, then as a matter of statutory construction, Bank Mellat Lim 1 impliedly excludes that right from the procedural provisions in section 40, and that's the end of it. We say there's no basis to distinguish Begum 2 on the premise that it was a national security rather than a SOC case or a SIAC case rather than an FTT case. The provisions are identical. The provisions creating a right of appeal, as I indicated in opening, are identical. They simply divert it into different venues. That being the case, Begum 2 is the answer to that point. Respondent's notice point 2, the application of the unpublished policy. This, of course, relates to the now infamous Fiona Johnson ministerial submission. The short point that we've made in our written case, based on 2 detailed considerations of this that we've referred to in the written case by SIAC, and now approved, albeit in obiter remarks, in the Court of Appeal in D5 to 7 and C9, is that the ministerial submission is just that. It is a ministerial submission in a conventional format which says to the Secretary of State, you have a policy, the policy says, and the policy already said, even at the material time, you could deprive in cases of serious organised crime, so why don't you start using it? And that would be consistent with what you said at a conference that you would do so and so on and so forth.
Right. I'm so sorry.
I'll just make sure I've got a correct note. The authority was D5,
I'm so sorry.
6, 7 and C9, is that
yes,
right?
I went to that too quickly, my lord. It's D5 to 7 and C9. There were joined appeals
Yep,
in the Court of Appeal. You'll find them in the hearing bundle behind tab 80, beginning at page 1488.
Yep, thank you.
I'm grateful. The passage in question is paragraph 24 on page 1494. I accept in the Court of Appeal that's an obiter statement because permission to appeal on that point had been refused by Lady Justice Andrews. But in the underlying cases, SIAC concluded twice that the ministerial submission in question was a ministerial submission and not a policy. But if I'm wrong about that, then the short answer to the point is that on the facts here, my learned friend's client had, and his representatives had, a copy of the submission and what was contained in the submission of material relevance at the material time to make submissions on it before the first tier tribunal. And if my ground 1 point is right, that the remedy by way of post-decision appeal to the FTT is an adequate remedy for those purposes, and there's no reason why he can make all the arguments he wanted to. Just to give some flesh to that bone, can I ask the court to turn up the skeleton arguments, which my Lord Sales rightly noted was not in the original bundle, but is in tab 2 of the supplemental bundle?
Just before you do that,
yes, ma'am.
I mean, looking at what the FTT decided, paragraph 70, page 162, they said it was common ground that the policy was to be taken to include both the nationality instructions and the recommendation of the 13th of May.
Yes,
so they read the policy as including the 13th of May submission, and then their reasoning follows through until paragraph 80.
Yes.
And essentially they reject the appellant's argument that his conduct could not rationally be assessed to be in the high category. So that seems to be the way it was played out for the FTT.
Yes, that's right. Marlo, can I make 2 points about that passage? One of them was the one I was about to come to, which effectively on the facts. The FTT considered it in full, considered the arguments that had been made about it with adequate time and ability to do so by the then appellant, the respondent today, and determined on the facts that according to the appeal tests that are properly to be applied, there was no error. That was, in my submission, an unimpeachable conclusion. So even if it's treated as policy, my learned friend's client has had the opportunity to challenge the conclusion within the parameters of the scope of appeal that he has in the FTT against that very decision.
So I was slightly struggling to see why it wouldn't count as policy. Well, you have the nationality guidance, which sets quite a wide test of conducive, but the Secretary of State then is told, well, how can I put it? Our policy is to only apply that in cases of, I can't remember the phraseology, but high profile or particular seriousness.
Yes, it suggests, I think it's in paragraph 7, that it should only be applied in the most high profile or most serious cases. That's right. But,
so why isn't that a narrowing of policy?
Well, all that is, it's not a narrowing of the policy. In my submission, that's simply a reflection of the fact. As my learned friend says, deprivation is a serious process, and deprivation has extremely serious consequences. It takes away the right of abode. It's not, if you like, for the Secretary of State, a remedy that is resorted to lightly. And so all that's being reflected there is a reflection of the significance and seriousness and intrusiveness of the power that the Secretary of State has at her disposal under Section 40, subsection 2. And indeed, even if the Secretary of State had not said that, or rather, even if that had not been submitted to the Secretary of State by Ms Johnson in the submission, I would respectfully suggest any advocate on behalf of the Secretary of State would have difficulty suggesting that the policy of deprivation could be applied in anything other than the most serious cases. If the criminality had been much less significant, had no organised element to it, and had perhaps only resulted in a very short community order or something of that nature, there couldn't be any serious suggestion that an appropriate response would be to deprive somebody of their citizenship. So in that sense, the policy is only reflecting the nature of the power, or rather the submission is only reflecting the nature of the power. And we say for that reason it's not properly to be described as policy. Insofar, I recognise I have to deal with this, at paragraph 70 of the FTT decision, it's said that it's accepted that the propositions advanced were accepted as policy. Of course, one has to read that in the context of what the Fiona Johnson submission does, which is to start with the policy itself in the nationality instructions. And so in that sense, what was said there was completely uncontroversial and a fair reflection of the submission. But as I say, if I'm wrong about that, and even if this is treated as policy, in any event, it was adequately considered by the tribunal on the basis of submissions that have been made. My Lord, again, to give that some context, the submission that was made, one can see in the first-tier tribunal skeleton on behalf of Mr Kolicaj, supplemental bundle tab 2, page 21, and at paragraph 18, at the very bottom of the page, you'll see this is issue number 6. There are 9 issues. Moreover, whilst the Secretary of State takes into account the cursory chapter 55, paragraph 55.4.4 in her decision, that's the nationality instructions definition you've seen, there's nothing in her decision to show that she's applied the agreed policy submission in the 13th of May, it must be submission, to deprive citizenship in cases of serious organised crime involving the highest harm, particularly those types of offending, thus contrary to the principle of good administration, see Mandalia. So the submission being made, the appellant at this stage having been provided with a statement initially of what the submission contained, and then ultimately the submission itself, the submission was, you haven't taken it into account. Well, of course, the answer to that was, yes, she has. And that was the argument being put, and that explains why it was dealt with in the way that it was by the first-tier tribunal.
Can I just ask you about this? I've just been trying to sort of understand the way the argument was framed before the FTT. We were shown, I think, the Secretary of State skeleton argument saying the relevant decision that you have to focus on is the original decision by the Secretary of State. It seemed to me that that essentially was common ground looking at this skeleton argument.
Yes.
It was that they focused just on that, and that's why one got into the sort of Thameside argument. Because
exactly. And it appears very much in the way it's drafted to be a Thameside argument. Well, I don't think Thameside is cited there, but Thameside is cited elsewhere. Well, look, that's right. One of the points my learned friend has made in opening this morning, which is entirely fair, is that there has been very substantial development in this area, at this level, in this cause, in the past 4 or 5 years, from Begum number 1 onwards. And at the point in time at which this case came before the first-tier tribunal, it's fair to say the position probably of all parties appearing before the tribunal was not completely settled, and there was still an enormous amount of debate. Witness the U3 proceedings very recently before this court as to what exactly was to be done. Now, you've heard further arguments about that today. My submission remains that whilst the Secretary of State has to consider material that's produced in the course of an appeal, that can be done in any number of ways, and there will be cases where it's perfectly appropriate, as here, for the Secretary of State to say through counsel, well, we maintain the position, because that's being said on the basis of clear instructions. Counsel always has to act on instructions. There will be others where something more detailed is produced, but there's not a one-size-fits-all approach. And here, it is fair to say that that seemed to be common ground. And even
just so my colleagues can follow my thinking on this, it's page 17 in the supplementary bundle, paragraph 9.1 of the Mr Kolicaj's skeleton argument for the FTT, and one sees that the submission is, for the reasons set out in the issues below, the decision of the Home Secretary dated 22nd of January 2021 is erroneous. So it sort of seems to be a classic, presented as a classic judicial review of that original decision.
It does, and of course, even with the U3 analysis, the decision that's under appeal is still the original decision. It's just it's maintained in some way through the consideration, or rather after the consideration of further material. I think, as my Lord put it in argument this afternoon, you have an implied maintenance of the decision.
That was the way Mr Kolicaj put it.
Yes. There's different ways of putting it. But that's absolutely right. We say it's understandable why the tribunal therefore dealt with it in that way. And indeed, in many cases, there won't be the need for the Secretary of State to say very much at all about it. In other cases, maybe perhaps a little bit more. It depends on what evidence the Secretary of State has to meet. But the point is, the tribunal process, just as in SIAC, allows that procedure and that consideration to happen. So that's what I say about the second respondent's notice point. And then finally, on the third respondent's notice point, no proper exercise of discretion, we say that that's not a fair characterisation at all of the decision in this case. The decision letter, of course, has to be read also in the context of the ministerial submission, which not only preceded it, but in fact annexed a draft letter to be signed. It's abundantly clear that a range of factors, including what was then known about Article 8, Section 55 considerations in best interests, and other discretionary factors were considered in that case, although the decision was squarely taken and is represented in the FTT decision as being squarely taken on the basis of the criminality. That doesn't mean all those factors were ignored. Far from it. The Secretary of State had the material before her, accepted the recommendation, and signed the letter that she was asked to sign. In those circumstances, it's abundantly clear that she was well aware of her discretion, and it is, frankly, an entirely unrealistic reading of the decision letter by the upper tribunal to have concluded that it didn't consider any exercise of discretion. Well, may I just have a moment to take position? My Lord, unless I can assist any further, those are my submissions in reply.
Thank you very much, Mr Blundell.
I'm grateful.
Yes, Mr Kolicaj.
Well, Lord, I'll be quick. So I think I have 5 points. Firstly, I'd just refer, Mullen and Friend said that Begum 2 is the answer. I'd just refer again to our written case. We say that Begum 2 is not the answer to the statutory context point for the reasons we've set out in the printed case, the written case, and particularly for the fact that when the Lady Chief Justice in Begum 2 is talking about the distinctive appeal right. She is very clearly, we respectfully submit, talking about SIAC and the protective procedures in SIAC over and above the consequences and the role of any tribunal hearing an appeal from a Section 42 decision. But you have my submissions on that already. On the policy points, it was the Secretary of this is just to cross a T, the Secretary of State's submissions before the First Tribunal, which identified the ministerial submission as a policy, are at tab 28, pages 307 to 308. The next thing is that we maintain the submission that by the time that Mr Kolicaj had the opportunity to make representations about the policy, that the cart had bolted, sorry, the horse had bolted, that the Secretary of State had taken her decision, and there is no evidence, we say, of a review. But, my Lords, if you're not with us on that, with Mr Kolicaj on that, I would invite you to consider the underlying question, which is whether the ministerial submission as adopted was a policy. In circumstances where, if your Lordships are of the view that it is a policy, then I would invite you to make a finding to that effect in the judgment, not least because there are two first instance SIAC decisions in which it's concluded that it's not a policy.
And they are, sorry, just so we can...
sorry, they're referred to in my learned friends' and they're D5, D6, D7,
I see those.
C9. And then, as Mr Blundell mentioned, Lady Justice Lang then refers to those in the joint appeal from those two first instance SIAC decisions. In circumstances, if you were of the view that it's a policy, I would invite you to make a finding to that effect. It may be relevant in similar cases in the future, not specifically about this policy. My Lords, you referred to a submission made in my learned colleague, Mr Hodgett's skeleton argument before the First Tribunal, just to say that, just to clarify that when he made those submissions, of course, he hadn't yet seen the ministerial submission. That skeleton argument was filed before. Mr Bundle referred you to the skeleton argument, which is in the supplementary bundle, and that was the one which was originally filed. Yeah. The Secretary of State responded with her skeleton argument, which attached the ministerial submission, and then the supplementary skeleton argument.
But I thought the ministerial submission we're talking about is the higher harm policy of the 13th of May.
That's right, my Lord.
That's referred to in this.
It is, because it's referred to in the. Ms Hodgett says he hadn't seen the ministerial submission. He'd seen
so he knew what was in it.
Well, he knew what was said about it in the December document, but he hadn't seen the submission itself. So,
I follow.
So it's quoted. A short extract from it is quoted in the December ministerial submission that had been filed in February. The skeleton argument follows from that. Then the May ministerial submission is filed, at which point you see the submissions, the short supplementary skeleton argument from Mr Selwood, and that's the way in which the case was put to the First Tribunal once the document had been seen.
Yes, I see.
And then the final point is about our last issue. My learned friend asks you again to read the decision itself, the decision under appeal, alongside the ministerial submission. I recognise that you may do that. What is regrettable about this case is that it wasn't served for over a year. It wasn't served for 11 months after the appeal was lodged. It wasn't served in the respondent's notice. And if you are of the view that the ministerial submission should have been and should be read alongside the decision letter, and that it would provide an appellant with the reasons why, with evidence of the exercise of discretion, the reasons why the discretion was exercised, and if my learned friend is right to say that it should be treated as part of the decision, then it should be served as part of the respondent's bundle. And again, I would, if your Lordships aren't with me on ground 5, I would invite you to consider whether to indicate that it would be better for ministerial submissions to be served alongside decisions, particularly if the Secretary of State is going to say that they form part of those decisions. My Lords, those are my submissions in reply.
Thank you very much, Mr Kolicaj. Well, we're most grateful to all counsel for their assistance. We'll take time now to consider your submissions and let you have our judgment in due course.